welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Jennifer Canine. Jennifer is an attorney with the law firm of Hopkins & Carley in San Jose, and she began in the law practice in 1989 after graduating from Santa Clara University School of Law.
Go Broncos! Yay!
Cum laude. She has an AV rating, which is the highest rating for attorneys in both practice and ethics. Jennifer's practice areas include estate planning, probate, special needs trusts, tax planning, and charitable foundations. She also works with many closely held and family businesses to plan their succession. She's married to former state assemblyman Jim Canine, that's where the Canine comes from, and they live in San Jose with their 2 children. Jennifer is a new member of the San Jose Rotary. Congratulations on that, Jennifer. Thanks. And in her spare time, she enjoys reading, movies, and travel. And today, Jennifer and I are going to be talking about planning issues related to real estate change of ownership in California. So you folks who are viewers that don't live in California, you might be interested in watching to say how fortunate you are that you don't have to deal with some of these planning issues. On the other hand, we have the benefits of Proposition 13, and so for us, this is an extremely important area of estate planning and personal planning. Jennifer, thanks for joining me today.
Thank you, Michael.
Okay. Now today, just to give you folks a frame of reference, it's November 4th, 2014 when we're recording this. There's no significant changes on the horizon that I know of. Although there are little bits and pieces that I'm hearing some buzzes about, probably that we won't be talking about today. Okay, Jennifer, let's let her rip. Why should California residents who own real estate be concerned about change of ownership rules when doing income and estate tax planning? Now, I should say one other thing. If you own property in California and you're not a California resident, you still want to pay attention. Okay.
There you go.
Okay,
good
Jennifer.
Point. Okay, well, if you are a resident of California or own property in California and you're not planning to sell anything or transfer anything to anyone, then you don't really have to worry about it too much. Mm-hmm. But for a lot of families in California, they worry eventually about wanting to transfer property to the children, mm-hmm. for example, or other people. So, and the issues mainly come up where a family owns more than one piece of property, because then there are some other considerations. For a lot of families, as you mentioned, Prop 13, there are benefits. And the whole reason for enacting Prop 13 back in the 1970s, which we probably barely remember, or maybe we weren't around,
I remember it quite well, actually.
So don't date yourself. So, but the reason is that property values were skyrocketing in the 1970s. As with most states, or maybe even every other state besides California, property taxes were based on value of the property, and they were readjusted based on value every year. Well, as California property values were taking off in the 70s, people became very concerned that they were going to be retiring and that they wouldn't be able to afford to keep their homes. So therefore, Prop 13, put in place by the taxpayers of California, and this rolled the tax values back a few years for people who actually already own property, and it also set rules for the future and through today. So that rule is that when you buy a piece of property, for example, you get your base on the assessed value usually equals the fair market value or the purchase price, and you're going to pay property tax equal to 1%. And there are, as everyone can see when they read the property tax bills, there are always a few add-ons. So you can probably safely assume it's probably closer to 1.25% by the time you add on the bonds and little add-on things. But 1% is the general rule. And every year thereafter, you can budget for what your property taxes will be, because you know that they're not going to increase, aside from any new bonds that come on the ballot and things, by more than 2% in any year. So if property values actually go up lower than 2%, then you're going to maybe have an adjustment that's even less than 2%. And as what happened with a few folks back these past few years when values dropped dramatically, you might even get a notice from your kind county assessor saying they're actually going to roll back your assessed value. But that's a temporary thing and can bounce right back as soon as property values recover, which as we know, has happened fairly well in the past couple of years.
Right.
So, families are concerned, and what they don't know sometimes is that they can't just transfer potentially every property they own to their children, for example, or to grandchildren or to other people without that being deemed what's called a change in ownership and then a reassessable event, meaning the assessor can come in and say, oh gosh, I know you were paying property taxes based on an assessed value of $400,000, but that piece of property is now worth $800,000. You've transferred it to somebody, and now we're going to start assessing it at 1% of that at $8,000 plus. So.
Right. So this is a big deal.
It can be a big deal.
Because if you have an increase, like some people have said, it's the gift that keeps on giving. I mean, as far as that, once you have a change of ownership, that means that, into the future, you're going to be paying this higher amount of tax.
Right, and so it's not possible to sort of undo that and get it back down, to the old value. And for a lot of families, with cost of living going up so quickly, it's actually important to keep family or allow family to continue to live. Say, for example, here we are in San Francisco Bay Area. I mean, even a lot of places in California, a lot of places throughout the country, it's important to be able to pass a tax base down so that children can afford to still live in the community they grew up in.
So just for folks maybe to have an idea of what's happened with property, if you're watching from another state, what have you. So my parents bought their home. Now I'm trying to remember what I sold it for, but anyway, they bought the home in Saratoga in 1958.
Wow.
For about $35,000. I sold it earlier this year, I think, for about $1.4 million. I bought my home in 1978. Not Saratoga, San Jose anyway, for about $100,000. And today, I'm guessing that the fair market value may be $750,000 to $800,000.
Yeah.
So I thank God when I get my my assessment notice from the county assessor and see, that I'm paying at a much lower tax base by staying in the same home for so many years. Okay.
It's nice.
So let's talk a little bit about reassessment and how it applies for families, particularly about exemptions.
Okay, so the general rule is whenever there's a transfer, it's, the general rule is it's a change in ownership and it's a reassessable event. But like you were just saying, there are a number of exceptions. And for families, the main exceptions would be between husband and wife, for example. So if, if you died, you would be able to leave, your house and other property to a spouse. There's also a very important parent-to-child exemption, and that exemption is for principal residence, and it's an additional for each person $1 million of assessed value of other real estate. And so the reason that's important is because, as you just said, let's say the property you're talking about here wasn't your principal residence, it was actually a rental, or you had decided to keep your parents' home and not sell it and wanted to pass it along to your own children, then you would actually be able to look at the assessed value of that property and not the fair value in terms of counting toward that $1 million that you can pass without reassessment. So it's a really nice perk for families that have owned property since the 70s and 80s or back to the 50s. It's a nice way to pass property among family.
So it may be that you could pass much more. It might be a couple million or more because the assessed value is still based on that Proposition 13 base.
Yes, we see it being far in excess. For a couple, of course, that's principal residence plus $2 million. So we've seen that leveraged into several $1 million worth of property just through what's called Prop 58. That's the parent-child, and that's the form you have to file when that transfer happens. There's also a grandchild exception for reassessment, but it's much more rare because the definition of child includes your child, your child's spouse, stepchildren, foster children. So as long as people are alive in that category, you can't give to the grandchild under the same exemption if either one of their parents is still living. But occasionally in a tragic situation where parents are deceased, The law was changed actually after this all went into effect. A few years afterward, people started realizing that's a little bit unfair to the grandchild whose parents are deceased. And there's now an exception on a limited basis for grandchildren as well.
Yeah. I actually went through something like this again. My parents have both passed, and so I had to go through the change of ownership process, filing processes and reporting processes for their home.
Right.
And my sister had passed away, but her husband was still living. I thought, well, he's not a child, you know. And then the county assessor says, no, as long as one of the parents is still living, we're sorry, but they do not qualify. So we have a reassessment related to the grandchildren.
Yes.
And so folks, be aware of that
Yes.
related to your planning. And I've even talked to people at title companies, and they were pretty surprised.
Yeah, and the issues are too that you really have to do the right reporting too. So, for example, on that parent-child exception, it's up to you as the person receiving the property or giving the property to file what's called that Prop 58 form to let the assessor know that you don't want that property reassessed. It's going from parent to child. If you don't do that within 3 years, or, and it better also be before the property is retransferred. So if parent left property to child, they held it for 2 years, and then they went ahead and transferred it, just sold it to a third party, for example. They thought they would keep that same basis for the first 2 years. Well, it's going to catch up to them. And eventually the assessor's going to realize, wait, you held it for 2 years, the Prop 58 form didn't get filed. Guess what? We're going to reassess it for those 2 years and send you a supplemental bill plus some penalties and interest for good measure. So it's very important to be aware of the rules, to have good tax advisors, that when you buy and sell property, if you are trying to preserve a property tax base, get advice. Get advice on it. Make sure it's done right, if possible beforehand, in case there's things you want to do for planning to help.
So since you brought it up, a little out of sequence, that's okay, but there are reports that need to be done, and actually the filing threshold, the deadlines are pretty tight on some of these things. You're supposed to actually file a change of ownership form within 30 days after death.
I think that's been extended now, I've heard.
Maybe, I don't know, but anyway.
But technically, you're right. I mean, it's whatever it is, it's short. So
yeah, it's short, and what I found is that attorneys, in many cases, estate attorneys, they don't seem to put a lot of priority on getting these reports filed. And part of it is, I think, that they're thinking about, well, I'm not even sure who's going to end up with what yet. And so that's a pretty good reason in some ways.
It makes sense, right? It's logical anyway to wait.
But what the county wants you to do is to tell them preliminarily what you think might happen.
Right.
And then you can fine-tune it later.
So what my office does is we file, even if the estate is quite large and there are several properties and we don't even know which of the children, for example, might want to take certain properties, we just immediately file the Prop 58 form just to make sure it's on file, because we don't want any property to be sold during the administration, for example, and lose the ability, or somehow someone forgets in that 3-year window. So we just do that. But you can always correct it and tell the assessor exactly what you're doing. But that raises another issue, that it may be possible to take a piece of property and give it just to one child. Let's say there's 3 or 4 children. But you have to be careful doing that, because it could cause a reassessable event by not exactly doing the property distribution pro rata amongst all the children. You have to be careful that there are enough other assets in the estate to go to the other children, and that the trust itself, if it's a trust, for example, allows for non-pro rata distributions among the children.
Right. So people may wonder, well, how will the county assessor know that something has happened? And ultimately, they will know because you're going to change the title. You know, there'll be a quitclaim deed or something.
Right.
And so when that happens, and there's a report that's given to the county assessor,
right.
So then they'll follow up.
Yeah, so a lot of things could happen. So if there is a trust, for example, just filing an affidavit of a death of trustee, our local county is starting to send out requests for parent-child, even just based on the death of a trustee. If it's a probate, you're going to end up filing, from the probate court, the change in title through the probate, or if there's a deed that's being done, something eventually is going to be recorded, and that will alert the county assessor. And they are quite savvy. They are looking for some reassessment money, and so they're going to likely follow up to find out what's happening with the property and should they be reassessing. And again, their assumption is we're going to reassess unless you tell us that there's a reason that we don't reassess. So.
Yeah, it's funny how they get motivated to try to collect some more money from you.
Yes.
Let's talk about a couple of things. What about gift tax planning? So there's also like an exemption related to some smaller transfers, right?
Right. Well, so there's a few interests there. So you're right. There is, so gift tax, so just as an overall basis, without even filing a gift tax return, any individual can give to anyone $14,000 a year right now. That's the annual exclusion. This year in 2014, it's the same in 2015.
Now that's for gift tax reporting, for
right.
federal gift tax.
You don't even have to report to the IRS.
Yes.
So you can avoid the reassessment by using sort of a de minimis sort of rule which says that if the gift you make is of an undivided interest in a piece of property, it's less than 5%, and it's also less than $10,000 in value, then you don't have to be reassessed. It's getting very difficult in California in particular to find that property where it's 5% or less is even under $10,000. So it can still be done maybe if you're just transferring a 1% interest, or if you're transferring property out in a very rural area. But you have to have it appraised and things, and so it can be kind of expensive to do.
Okay.
So it's possible, but it's not used very often anymore. Early in my career, we were using that on a more regular basis.
Okay.
But for gift purposes, in general, we're talking about the property taxes, but there are also gift tax considerations. And before the tax laws changed a few years ago, there was a not very high cap on when gift taxes might start to apply to a gift. Now with the new legislation, taxpayers each have more than $5 million that they can transfer in addition to that $14,000 a year exclusion amount without having to pay any gift taxes. They do have to file returns over the $14,000.
Right.
But so now we're finding where folks, when the estate tax and gift tax rates were up to 55%, and they were really more worried about saving and not having to pay those gift or death taxes. They weren't so worried about the property taxes. Now I feel like the tide has shifted a lot. There's more ability to give without death tax, so families are starting to focus on, gee, I have a few little rental properties, I have a duplex here, a little strip mall there, a couple of rentals. How do we transfer those to our children without being reassessed? So.
Okay. So what about planning with family partnerships and so forth?
So for investment or business property, it's possible to use entities. And entities is a completely different set of rules than those family exemption rules. So for, let's say, for example, a partnership or LLC, which is a limited liability company, or a corporation, those are the main kinds of entities that folks use for transfers. They are under a whole different set of rules. And one thing to know is that even if a family forms, let's say, a partnership, and thinks, well, we can maybe use some of these entity rules, and we'll also use the interfamily rules to transfer entity interests to get property transferred, let's say, to younger generations. That actually isn't true. If you're in the entity rules, then you can't use the family rule exemption rules.
Okay, so what we just said, folks, just to review, is remember we said that you can get $1 million exemption before for a direct transfer of a real estate interest to your child, and in some cases to grandchildren. But what we just said is, if it's inside of an entity, so you make a transfer of a partnership interest, even though the only asset of that partnership may be real estate, you are not going to qualify for that $1 million exemption.
Right. So, but it's a consideration of how you want to make those transfers and how much real estate do you have. So you might want to transfer your principal residence in a vacation home under those family exemptions, but then you own, let's say, a little strip mall, and it's worth $3 million, for example. And it probably makes sense to have it in some kind of limited liability entity anyway, whether it's an S corp or usually it's in a limited liability company, maybe a limited partnership. because you want to limit liability for the family anyway. Well, then the rules are different. So if mom and dad, for example, owned that property and put it into the entity, they're subject after that to 2 rules. First, they can transfer up to 50% of the interest in the entity without any reassessment. And that can go to children, grandchildren, nieces and nephews, outside third parties, whoever they want to transfer to. It's completely exempt. Once anything over 50% is transferred, the entire property in the entity is reassessed. Or if one person who is currently a partner who doesn't have a controlling interest gets a controlling interest, 51% for example, then the property is all reassessed. But there are some interesting techniques to work around those rules, but those, you know, and they usually work best if you have family members involved.
Okay. So there's some controversy related to this, and we may be seeing some tax law changes, but right now it looks like you can even transfer more than 50% provided nobody gets a majority interest.
Well, so yes and no. So if an entity is set up, and let's say it's called ABC Partnership, and let's say the partnership itself purchases the property, then as long as nobody gets over 50%, there's no reassessment. If you go the other way, where mom and dad own the property individually and decided to put it into an entity, that's where you have to track those cumulative 50% transfers. And that's how, for example, if you have a company, a local company that buys property, why they don't really worry about reassessment. Well, that's because nobody's going to get a controlling interest. But for property, a lot of families bought property and didn't buy it into an entity, they transferred it later. Then where there's that exempt transfer into the entity, because that's not reassessed, then there's the 2 rules you have to do. But the way you actually, there are ways to work around that reassessment even when you have both rules, the dual rules working, where we've helped families. And again, this is, you know, all based on what the current situation is, and these rules could change, and there's obviously always discussion about changing laws. But sometimes you're able to actually pull property back out of a partnership, do some small jiggling of interests, put it back in perhaps to a new entity, and start those rules over again. Under current law, the State Board of Equalization does not invoke the step transaction, meaning they're not going to collapse all those transactions and say, hey, wait, somebody got control, more than 50% of interests were transferred. They're not doing that right now. That's not to say that they won't change their ideas and position on that someday in the future.
Yeah.
So
folks, I hope part of what's going on is that some of your eyes are sort of spinning out there, and you're saying, well, what are these guys talking about? Well, really what we're talking about is that these rules are complicated, and so you need to get guidance from people that are familiar with them and strong in this area, and it comes into a lot of family planning, particularly, again, when you're interested in using entities as a way of doing family wealth shifting. And there can be estate tax reasons for doing that. You know, again, if your family has property in excess of the 10 million or so that mom and dad can pass tax free. There can also be income tax reasons for that, because one thing with real estate is by giving it to them, basically you shift the income from that real estate to the family member. But again, these things all have an effect on this Proposition 13 considerations. So there's the income tax and the estate tax and the generation skipping tax, and there may be a state inheritance and gift tax. And basis.
And do you want a new basis or a carryover basis?
There's basis issues as far as income tax, again. And this reassessment thing. And so, anyway, so there's a lot of dimensions. It's like playing, 4 or 5 or 6 or 8 dimensional chess. And most of us are not familiar with the details of how these rules work. It's even hard for the attorneys, believe me. I'm sure that they worry about, okay, is this all going to work out?
Right.
Okay.
Right. Wake up in the middle of the night sometimes thinking, okay, do we think through every aspect of the proposed transaction? But it is unfortunate that if you are a person with sort of complicated property holdings and there are priorities of properties that you really want to keep in the family or need to keep in the family because of family businesses, it's just multi-generational, trying to transfer a business down and the property that it's on, you do have to be careful, and it's unfortunate that if you can afford it and go seek help, it might come out better than if you don't. So.
Right. There's another thing that I want people to be aware of. When they have these businesses, there is a question on the income tax return in California for corporations, S corporations, partnerships, and LLCs or taxes partnerships, where they ask, was there a change of ownership, a cumulative change of ownership during this taxable year? So you're answering this under penalties of perjury, and then of course if you answer yes, then that is going to be passed along and people are going to start asking questions to get reassessment information.
Not to mention that in addition to those family reporting that you need to report within 30 days, 45 days, 3 years, but then on the entity transfers, the Board of Equalization has a whole other scheme of things, and there's a form that needs to be filed very quickly.
45 days.
It may have extended it to 90, but it's
right.
very short.
I need to double check on these.
It's very short though, and if you don't file with the state board, they can assess a 10% penalty on what would have been the reassessable event on a change in ownership on the entity. So it's very serious.
Yeah. So you need to really watch and keep on top of this paperwork filing, and because I'm a CPA, right after Mom passed away, I made sure that I got the paperwork going.
Yep, you would be the first stop to all those things, and if you are overwhelmed by the legal issues, then you tell them to contact their attorney.
Yeah,
but,
right.
Yes.
Folks, I hope that we've given you a little more appreciation for this change of ownership area, and also then this is going to be the beginning of a conversation with your own attorney and advisors related to this. Jennifer, thank you so much for joining me today and being my guest.
Thank you.
Okay.
It's my pleasure.
Folks, we'll see you next time on Financial Insider Weekly.